One thing that I think is interesting to muse on is what exactly does the multi-factor test give us? Is it helpful to arriving at conclusions about whether or not a likelihood of confusion exists, or is it a detriment to the trademark system? And I think there's a variety of perspectives we could take about what the multi-factor test gives us. For one thing, I think we can tell conflicting stories as to the question of whether or not it produces more or less accurate results. Those who might favor the perspective that says it actually gets us something by way of accuracy is to argue that it gets courts or fact finders, in the case of juries, to think about key points. That is, insofar as we think the factors correspond with questions that are of relevance to whether or not there's a likelihood of confusion, it may be useful as a checklist for the fact finder to kind of go through and think about whether or not those elements are actually present. Is there actual confusion? How close are the products in the marketplace? How similar are the marks? Now, of course, the flip side is that perhaps having all these various factors and this idea that you have to think about them all, you're opening the door to a certain amount of manipulation. That is, you can have certain key factors that may not be squarely in favor of the plaintiff, but if enough ancillary factors look in the plaintiff's favor, a court that may already be inclined for one reason or another to find in favor of the plaintiff may be able to concoct a rationale that there is in fact a likelihood of confusion, notwithstanding, say, the relative lack of similarity between the marks, and vice versa if a court is particularly inclined in favor of a defendant, notwithstanding the presence of evidence of potential likelihood of confusion. And so this possibility that structuring the analysis to think about certain things that may not necessarily be relevant might actually obscure the issue at hand by allowing a fact finder or by tempting a fact finder to think about issues and factors that don't necessarily matter. But I think if we're trying to evaluate the merits of the multi-factor test, the accuracy of the ultimate outcomes is really just one question. There's other interests that may be implicated by the operation and framing of the multi-factor test. One potential argument concerns the amount of accountability on the part of courts when they're engaging in their fact-finding role. The likelihood of confusion standard is vague, and it's possible, perhaps, that having a reviewable test or channeling the analysis into the set series of factors that then can be reviewed by an appellate court may limit, to some extent, judicial discretion below, insofar as the lower court has to structure the analysis in a way that dots the I's, crosses the T's, and makes sure that the relevant factors are considered. But perhaps another possibility is that when you have a lot of different factors that are manipulable by the fact finder, you're able to insulate your conclusions from judicial review in a way that might be more difficult if you just had to give a straightforward explanation of, there's a likelihood of confusion, I think the reason is X, I think the reason is Y. Another argument or another factor to consider in evaluating the merits of the multi-factor test is the possibility that it enhances transparency. It gives a structure to the inquiry and then finally to the review in a way that allows the parties at hand to know what they are supposed to do, what kind of facts are relevant, and perhaps it provides a basis for lawyers to know exactly what's going on. Inquiries like the sort of Professor Beebe's in thinking about which factors are actually relevant. Because we have stable multi-factor tests, we are able to perform empirical analyses to determine what factors actually guide the courts in a way that perhaps we would not be able to in the absence of a stable set of factors. And maybe litigants, therefore, are better able to assess the likely outcomes of their case and the strength of their particular arguments. And again, here too, maybe though the multi-factor test is used more to obscure than to find facts. And the argument undermining the strength of the multi-factor test in this regard is sort of point to things like the bad faith factor, as we discussed in an earlier lecture, is capable of a good amount of manipulation by the courts, and yet we see plays an outsized role in the ultimate conclusion of the courts. But again, here too maybe is a form of transparency, that litigants, by virtue of looking at how the good faith factor is used by the courts, are put on notice that if you are a trademark defendant and a plaintiff is able to paint you as being some kind of free rider, you are at a substantial disadvantage in a way that perhaps is not intuitive based on the idea of whether or not your mark is actually likely to cause confusion.